we're back again. What I want to do is really pull together this overview. Actually, before I do that, any observations or comments that you want to make after meeting Georgia and having that chat?
I'm curious, like, as a pessimistic person, I feel like
You're born to be a lawyer.
I feel like she painted a very positive picture of like women in the law, which is great. It's good to hear that it's improving. But is it really that equitable yet, do you think?
You know, I must admit, I sort of side a little bit with her there, and maybe that's just based, well, I know it's completely anecdotal in the sense that it's based on my experience. Having said that, I know that the numbers don't weigh with me. But the reality of my experience has been really since the very beginning, and lots of shitty things happen to me as a junior lawyer, there's no doubt about it. But shitty things happen to young men who were junior lawyers too, or gay people who were junior lawyers, or Aboriginal people who were junior lawyers, or people of colour otherwise. There is some really unhealthy stuff in that power dynamic. So I guess I've never really particularly, well, that's not true. In one instance I can think of, there's some stuff that happened which was around pay parity, which the only thing I could put it down to at the end of the day when I found out there was a differential was gender. But on the whole, my experience has been if you're smart and you're prepared to work hard, you're prepared to put the hours in. I mean, there's a lot of grinding in the job early on. If you are open to giving back and not really thinking too hard about where the return's going to come from up front, that being a lawyer has been a fantastic career for me. So I started in the late 80s in a large law firm. I started as a paralegal, well actually as a word processing operator and then a paralegal before I was admitted. My last year of law school there was a massive stock market crash and many of the firms halved the number of graduates that they ended up taking in the year of that I went in. But I got a good place. I was supposed to rotate the same way that Georgia explained beforehand, but I ended up, I worked with this partner who actually, on paper, he was an arsehole. There's no doubt about it. He was not a great human being, but he did really interesting work, and he did actually value my input into that work and actually had the advantage of being slightly lazy. So he was giving me work that was probably somebody who was a better supervisor than him probably would have looked at a little bit more carefully. But those of you who've been in my classes know I usually set any problem with Dennis Denuto as being your supervisor, because I learned through experience that having a supervisor who you know probably isn't going to look too carefully actually means, okay, you might have some sleepless nights, and if you're an overly anxious person it probably wouldn't be too good for you. But for me it kind of worked because I knew the buck stopped with me from the beginning. And so I worked for 8 or so years in large law firms, and then I worked in an investment bank for a couple of years, and then I worked in medium-sized law firms where I was a partner. I went sort of straight into a medium-sized law firm. I was simultaneously the first female partner and the first non-Jewish partner, although I became partner at the same time as another man who was Muslim. So it was like the Jew, the Catholic and the Muslim walked into the bar and nobody wanted to pay the bill. I'm not quite sure what the punchline to our joke was, particularly as Ghulam didn't drink, so it could have gone anywhere. I've worked in a whole range of different areas. So I've never been a litigator, but I started off in natural resources and major projects. I worked into technology, I've worked in financial services. I've worked all over Asia, I've worked in Northern Africa, I've worked in Eastern Europe, I've worked in the States, I've worked in London, I've worked here. The law has been fantastic for me. I was a single mother when You know, I was 28 and working in a large law firm, and I could make it work. I've had 2 kids over that time. I've pretty much not had a day off. A lot of people would think that that was pretty unhealthy. But look, and there are plenty of my peers who I went to law school with who make a hell of a lot more money than me, who had a more traditional straight line, big firm, partnership, you know, whatever. Most of them have got mistresses and smart, fast cars now, and you know, they're pretty miserable, but that's probably me just being unkind, because they are a lot wealthier than me, or they have a lot more access to credit than me. I'm not quite sure which. Where I, you know, but I have had a happy and interesting life. So yes, there has been one occasion when in fact this is what led me to go to the investment bank at the end of the day, was I realised that the other senior associate in the team that I was in was earning about 35% more than I was. Now he had a couple more years experience than me, and at the end of the day, though I was billing more than he was, I was working just as hard, I was doing interesting things, and I found out by accident. Actually, I found out because he found out by accident, and he told me because he didn't think it was fair. Again, so the way I found out suggests that the culture that I was in was not discriminating against me. I guess now, that was the mid-90s, late 90s when that happened. Yeah, mid-90s actually. And, you know, nobody'd heard of Sheryl Sandberg back then. We weren't leaning in. I guess a lot of the social science stuff that's been done about women and men in the workforce, and a lot of that research hadn't happened. I suspect now that's more around the way I negotiated salary than it was around gender, actually. But at the time, the only thing I could put it down to was that. So I guess that's a long-winded way of saying I think it's a really complex problem, and sometimes we see the problems that we're looking for, but paranoid people have enemies too, and sometimes the problems we're looking for are there. So I think it was a lot harder than it is. I suspect it is harder than it should be for some minority groups in the profession. I don't think women are a minority group in the profession anymore. When you're working in law firms, often we'll be talking about the lack of women in the law, but you'll be in a law firm and 80% of the people who work there are women, whether they're the majority of the junior lawyers or the absolute majority of the support professional and management staff. And I think the cultures have changed a lot, and I think there are a lot of people of my generation who were treated pretty badly back in the day, and some have continued to mirror that behaviour. There's no doubt about it, but I think a lot of us thought, well, how could we be better at this? And also a lot of us also thought, if the only way I can feel good about myself is by making a young, smart person feel crap about themselves, well, I need to change something about my life. And I personally, one of the things that makes me feel good about myself is seeing people grow in the profession, because the profession's been really good to me. That felt like a sermon. Do I get it? Hallelujah? So, but yeah, I think she's optimistic, but I'm also with her. So, I want to talk about, I wanted to start off with these high-level duties and think about how these high-level duties fit in the actual selection of clients, dealing with clients and understanding how clients work. And we can talk about these individual things, but I think probably what is more useful is to break them down into these categories that you'll see quite often, and which kind of create a natural hierarchy. So above everything else, lawyers have a duty to obey the law. So our duty to the law sits ahead of any duties that we have to anybody or anything else. The next duty in the hierarchy is the duty that we have to the court. Now, more obviously, that fits with litigators and with barristers in particular. But our duty to the court is still, no matter what we do, what kind of role in the law we have, it remains paramount and higher in the pecking order than the duty that we have to our client. And our duty for the client sits there above duties that we have to anybody else, including our partners in our law firm, including our employees, including our lovers, our significant others, our children and our pets, and ultimately including ourselves. So just going back one again, I'm sorry, all the animation here makes it a little bit crazy. So this idea of acting zealously for our client is always tempered by our duty to obey the law, our obligation to obey the law. It's always tempered by the obligation that we have to the court. And acting with honesty and candour, again, might well fit within acting zealously for the client, might be tempted, might be tempered by that, but again might be brought out by the obligations that we have to the court or to the law generally. So basically, when we think about the duties using these different heads, we tend to break them down into these different kinds of areas. So first, loyalty. The duty that we have to be loyal to our client. And that plays out in a number of different respects. Being loyal to our client requires us to keep their secrets. Being loyal to our client requires us to act in their best interests and find the best case for them, tempered always by our duty to the court. We also have this duty of competence, that we need to maintain an appropriate level of competence in the matters that we deal with. So when Georgia was talking about the cab rank rule only, half an hour ago, the cab rank rule identifies or includes in it that the matter needs to be within the barrister's area of competence. The duties to the court sort of all fall together under one heading. So that's the duty to inform the court of all relevant matters in relation to a particular circumstance before it, which includes telling the court about cases, precedents, or ways of reading the law that might be contrary to your client's best interest. So think about the hundreds and hundreds and hundreds of legal advices that you've been writing while you've been, it feels like hundreds, I know, while you've been doing these different subjects. The ones where you did really well, it's more likely that you not only provided a straight set of authority that said your imaginary client or put them in the best position, but they also explored alternative ways. So if they're making an assumption, if your assumption turns out to be incorrect, then this is what might happen. Or if the court doesn't follow that line of authority, it will follow this line of authority. The reason you did better in those is because the court needs to be fully informed as to what the law says. And ultimately, the obligation to obey the law. So juggling your duties needs to sit within a framework of compliance as well. So as we think about those things, I want to think about what it means to have a duty to the client. Sorry, lots of words on this slide, and I must admit I'm one of those people who tends to read their slides when I have a lot of words on them, because I work on the basis that I put them there for a reason. Now this is under the old rules, because the uniform law doesn't really have this same kind of summary preamble, and I think it remains really useful as guidance for what we mean when we talk about having a duty to the client. So lawyers or practitioners should serve their clients competently and diligently. They should be acutely aware of the fiduciary nature of their relationship with their clients and always deal with their clients fairly, free of the influence of any interest which would conflict with the client's best interests. Practitioners should maintain the confidentiality of their clients' affairs, but give their clients the benefit of all information relevant to their clients' affairs of which they have knowledge. Practitioners should not, in the service of their clients, engage in or assist conduct that is calculated to defeat the interests of justice or that is otherwise in breach of the law. So this paragraph, ideally supported by appropriate citations, which you'll find by wandering through the case law and your text, ultimately sums up everything on one page you need to know about your duties to the client. You need to absolutely understand the fiduciary nature of the duty. So what is a fiduciary duty?
You can't gain unfairly from that relationship. You've always got to put the trustee first.
Absolutely. That there is no possibility of gain, that the beneficiary of the fiduciary relationship needs to be put first in all circumstances, and that the fiduciary should not benefit from the relationship even if the beneficiary doesn't suffer. So it's the highest level of trust. So what other kind of relationships are fiduciary relationships?
Doctor-patient.
Sorry?
Doctor-patient.
Doctor-patient, yeah, often. What else?
Employee to company?
Employee to company,
Inequity.
might be, yeah. Inequity, it might be. Trustees are probably a really good example. So a trustee is the legal owner of property or the legal holder of rights, but holds them entirely for the benefit of a third party. Any of you done equity and trusts?
Yeah, I did equity trust.
Oh, it's just an indication that you've done it, not that you've got it.
Directors?
Debt collectors?
Directors?
Directors are a really good example. So the weight of a fiduciary relationship is probably not quite as high as trustees and solicitors in this, but it's a really good example that they have to act in the best interest of the company, identifying what the company is, what the best interest is that does that mean for the shareholders, does it mean for the employees, does it mean for creditors, will depend on different circumstances. For lawyers, it's always the best interest of the company, of the client. So that this means that they have to always deal with their clients fairly, free of the influence of any interest which may conflict with the client's best interest. So right at the very beginning of any client relationship, any potential conflict needs to be identified and dealt with.
What happens if you completely inadvertently don't realise a conflict of interest? Is it automatically a problem in terms of conduct?
It is. That's something you'll cover a couple of cases that deal with exactly that kind of scenario when you get to the conflict section. But it really comes down to ultimately a question of what's objectively fair on the basis it's a fiduciary relationship. So there have been cases, for example, where a barrister some 10 years before had a conference with somebody, I'm going to grasp at the actual facts here, but had a conference with somebody, got some general information about a matter, 10 years on, had another discussion with somebody else, took that person on as a matter, realises later, or maybe even didn't realise, that they had information that was relevant to their client's affairs. So then they end up in the situation where they've got a client from 10 years ago where they knew, who's given them information that they have to keep a secret. And then they've got a client now and they've got information that they've got an obligation to keep a secret about, which is relevant to that client's affairs. And so in order to zealously act for this client, I've now got knowledge of information that is relevant. So exactly this third sentence here, practitioners should maintain the confidentiality of their clients' affairs, but give their clients the benefit of all information relevant to their affairs that they have knowledge of. So then they're in a conflict situation. I've got something, I know something about this property development or whatever it was that would help you, but that information I have is a secret from someone else. So that brings up the question, well, what do they do? What do you imagine that they have to do in those circumstances?
Tell the client.
Well, if they tell their client, then they're breaching...
No, that they have a conflict.
Oh, tell their client that they have a conflict, okay. Yeah, ultimately that's right. And usually they have to withdraw. But it's a very blunt instrument though. You find out late, your client then needs to get new representation. Other solutions could include getting permission. There's one case I know where that particular situation occurred and there was found to be a conflict and the barrister needed to withdraw, not so much because they actually had the information, but there was the perception that there might be a conflict. There was a perception that they may not be acting in the best interest. So these cases can actually fall into the realm of the client's perception can be your reality. Practitioners should not, in the services of their clients, engage in or assist in conduct that is calculated to defeat the interests of justice or that is otherwise a breach of the law. So that really goes to things like guilty or not guilty pleas. If you know your client is guilty, you cannot act, well, you can act for them, but you cannot be involved in the making of a plea to the contrary. One of the many reasons that many barristers might set limits early on, or many advocates might set limits very early on what their client tells them or not. That if your client, and you look at some cases here, for example, where it often becomes an issue here is when there's information that you get hold of or that you become aware of that might show that your client is about to, for example, take their children out of the country contrary to an order. What you have to do in those kind of circumstances. So those are the sorts of examples of circumstances where the type of conduct or your duty to the client sits under the duty that you have to the court and to obey the law.
I'd assume that in the interest of justice would also now be informed by the overarching obligations in the Civil Procedure Act?
Yeah, I must admit I'm not overly familiar with the Civil Procedure Act, and this is something I keep having to remind myself to remind you guys of, because a lot of you will be doing civil procedure at the same time here. And again, a little bit more conversation about siloing and the way that we deal with things. But when you are answering problems for this subject, quite often they'll look and feel like civil procedure problems, and you need to actually remind yourself how awesome it is that you recognise a civil procedure problem, but particularly in an exam, answer it as an ethics, Uniform Law Act problem rather than go through the civil procedure motions. So, but yes, you do need to justify those, and it is granted, it's kind of ridiculous that we need to separate them out, but it is a bit like looking at the various elements of a contract. At the end of the day, it really doesn't matter. You need to understand there's a contract or there isn't. It becomes kind of self-sufficient, but you need to be able to pull apart the separate parts and understand the whole better for your understanding of the separate parts. Where I thought you were going to go with that question too is that there is other legislation that can sometimes sit over which fits within our duties to obey the law. For example, where there is the potential for imminent harm to be done to a child, mandatory reporting obligations, for example, that now sit in a cleaner way than they might have previously. Though one of the things that's really interesting for is there anyone here who's doing the social work JD double? Because the mandatory reporting obligations are different, and so working as a social worker, or for those of you who might be doing volunteer work, for example, in the mental health legal service, where you may from time to time be exposed to concerns about somebody doing harm to themselves or others, the obligations in relation to reporting are different when they're seeking legal advice from when they're seeking psychological or social work help. So you need to understand what your own obligations are. Having said all of this, there is this long-held belief that regardless of anything else, our duty to the client comes first. This is the stuff that television soap operas are made of. You know, this is what, think of all those legal shows which are always really about an ethical dilemma, aren't they? Something that somebody could say or shouldn't say and the reason why it's a secret. It's a really old case here, I think deals with it quite beautifully. 1820s case. George the IV had alleged that his wife had committed adultery. And adultery was essentially, well, when you're married to the king, was treason. So the concern was amongst the bar at the time is, well, what do we do? If we are actually acting for someone who's accused of treason against the king in these circumstances, isn't this just the end of our careers? And Lord Brougham, or Brougham, I think is how you say it, did phrase this, and so I think it's just a beautiful paragraph, did phrase it that he didn't actually need to defend the Queen, but if that defence was necessary, so if he was to actually argue a treason defence against the King, he said, neither I nor the youngest member in the profession would hesitate to resort to such a course and fearlessly perform his duty. An advocate, in the discharge of his duty, knows but one person in all the world, and that person is his client. To save that client by all means and all expedients, at all hazards and cost to other person, and amongst them to himself, is his first and only duty. And in performing this duty, he must not regard the alarm, the torments, the destruction which he may bring upon others. He must go on reckless of the consequence. So this is the culture that we come to. Technically, our duty to the court, our duty to obey the law are higher in the hierarchy. But they don't show their faces as conflicts very often. And this strong duty really drives the way many lawyers, particularly advocates, think. Tell me, are any of you using this text at all? The, what's it called? The Parker and Evans one? No. So in the teaching notes or in the study notes, it refers to this book and some of the case studies that are in it, which are excellent. And in fact, if we get a little bit of time, I might talk you through one of them as we go.
Online.
Sorry?
You can borrow it online through the library.
Oh, you can borrow it online, can you? Oh, that's good. It's look, it is really absolutely excellent. And one of the ways when we had it as a text all the time, it's got a see, you can get it online. Actually, I really will recommend it to you. There's a little like survey that it asks you to do where you can go through, and it asks you about 40 questions, I think. They're towards the end of the book. I can send it to you as a Google survey because I've done it in class this way as a Google survey before. It basically asks you, go through, do these questions. What do you agree, strongly agree? You can give yourself points, and it basically puts you in one of these 4 categories that they come up with. And the categories are based around, and there's some information about it in your topic notes, so go and have a look at it. But essentially, they've asked themselves a really sensible question. We all understand what the ethical duties are, but we all respond to ethical duties in different ways, because ethics is ultimately about choosing between 2 wrongs, and working out what is the bigger wrong, the lesser wrong, will depend on a range of different things. So one of the categories, so this falls into what they call the zealous advocate. So the people who, in looking at the kind of role that a lawyer has, really push and feel comfortable with the idea that I can work with the serial drunk driver, I can defend the serial killer, I can defend the pedophile even when I know that what they've done, because I genuinely believe that everybody has the right to the best defence, and that despite what other people think of me, despite how it impacts my family or my own reputation, that's what I'm going to do. I'm going to fall within this zealous advocate approach to dealing with this. Forgetting off the top of my head the other categories, but it also looks at another category which looks at, well, actually the role of the lawyer is to make the law as good as the law can be. And so maybe it's not our first primary goal to be the zealous defender of a single client, but to find areas where the law is letting down society, find the test cases, find the way to get the law to be moved in the right direction. So look, again, particularly if you can get it online, it provides a great framework for thinking about your own response to the cases and otherwise. Another really good example of the zealot advocate is David Fagan, who was the, back in the noughties, the chief executive partner of Clayton Utz. I smiled before knowing I was going to give you this slide when Georgia mentioned that firm earlier. So this piece is taken from an article that Margaret Simmons wrote in the Sunday Age back in 2002. Now, you will have come across the Rona McCabe case at some time across your travels. Do you remember that particular case? Clayton Utz acted for British American Tobacco. Rona McCabe was very, very ill. In fact, she was dying and they were drowning her with discovery. Her lawyers came back with more discovery about some documents that they believe that British American Tobacco and some of the other tobacco companies might have in relation to work that they'd done about the potential ill health effects of cigarette smoking. And Clayton Utz had advised that particular firm, and a great deal of documents, great number of documents had been destroyed or weren't able to be found, and that was delaying discovery. And the question ultimately became, was the law firm itself delaying the course of justice or using unfair tactics in the way that they dealt with their discovery action or activities, and the advice that they gave about document. They had what was called a document retention policy, which was really about destroying documents more than anything else. And what was their role? And so David Fagan was asked in a newspaper article about that, what role a lawyer should play if the client was proposing to do something that was legal but immoral, on the general understanding that destroying documents that at the time it wouldn't have been illegal to destroy them. At the time, an action had been anticipated but hadn't commenced, so there were no rules at that particular time that would prohibit the destruction of evidence. And Fagan said, I'm struggling to see where there would be a case where that would actually arise. The clients are entitled, obviously, to avail themselves of the full protection of the law, and lawyers are there to advance their clients' interests subject to the constraints of their professional duties and, in particular, their duties to the court. But if they operate within those constraints, then they're acting appropriately. We don't take a moral stance, and it's not up to us as advocates for a client to take a moral stance. Ultimately, that comes to a decision by the client, not the lawyer. So what do we think about this? You can see what Larson thought about it at the time. What do we think about this? Do we take a moral stance? Is it possible not to take a moral stance?
Clearly. I mean,
Clearly it is possible not to take a moral
absolutely,
stance.
clearly. I think they're just outsourcing the responsibility for ethics, aren't they? They're just saying it's got nothing to do with us. It's entirely up to the client, and we're at the client's behest, which is just a, you know.
We're at the client's behest. We're advisors.
Yeah. They
We
instruct.
don't
We do.
But if they don't do that, how does the pedophile get representation? Or do we not care? Like, if we don't, if we aren't prepared to stand back and say, our role is to be an advocate, our role is to ensure that the law is applied fairly, ours is not to make a moral judgment, how would the pedophile get an advocate? Or how would your lovely, somewhat faggy uncle in 1890 get a fair hearing when accused of sodomy? Morals change over time too. Sorry.
Surely every barrister in Melbourne would be the zealous advocate, though. How can you not be? Because you can't be like half-in. You can't like pick and choose whether to go hard or soft for a particular client, can you? I mean,
No, I don't think
you
you
have
can.
to just be 100% or nothing.
And this is actually why I think that this exercise in the Parker and Evans book is a really good one, because I think it's one thing to say I can be a zealot advocate, but it's another thing to actually go through that process. So we've got a couple of students who are on internships at the moment who are, so there's one who's shadowing a barrister who's saying to me the other day, it's like, he's just getting these drunks off. Like, there's this serial drunk. He said, you know, it came to court pretty much pissed, and yet the police are disorganised, they haven't got stuff together, and the barrister's got him off again. And this particular student, you'll probably work out who she is as I say this, because she's a paramedic. But she's thinking, in my other life, I have to pick up his victims off the side of the road.
That's the system
How
we
does he
have.
sleep at night? And actually, and so think about that. How does he sleep at night?
I read a really interesting article today from a defence barrister, and he said it's interesting because every defence lawyer gets asked all the time, how can you defend someone that's committed these terrible crimes, or you know they're guilty or whatever. He's like, but interestingly, prosecutors never get asked, how do you prosecute innocent people? And like, it's sort of making the point that because the public align their morals to the prosecutors as the good guys, but and so defenders get these bad reps, but like they're not really bad people. They're just doing their job.
It's some
It
ways
was
it's a
just like-
fundamental attribution error that we're like, oh, it's
Yeah.
this person defending these people.
Yeah, so it's like he was saying, like, we get such a bad reputation because it's like we're not the good guys, but really, like, we have a system that needs like adequate representation on both sides for it to
And,
work.
oh, sorry, Georgia.
Zealousy kind of contradicts fair representation and proper representation, and there's kind of notions of what access to justice is. Like, I agree that like people have to do these jobs, but then do they they still have a duty to the court. So in getting people off when they highly suspect on all material facts that they're guilty.
But no, I'm going to argue with you there. Like, I don't want people to go to jail because somebody highly suspects they're probably guilty. I'm quite like a standard of proof that is beyond a reasonable doubt.
Oh,
And so, you know, it's not the barrister's job to be the judge.
Oh, I definitely agree with that. And I'm not saying that they should get some standard representation, but sometimes.
I know you're not. I'm
Yeah.
trying to
Oh,
get a vigorous conversation going.
But sometimes I feel like on particular issues, if you are taking a particular line of argument, there is that moral need to be like, no, that's contravening my duty to the court.
But what if it's not if you're not
actually-
pushing your argument, maybe if it's just the prosecutor's disorganised, they don't have the information, you've got a problem with the chain of custody. Yeah, my client's standing next to me, absolutely reeking of alcohol, and I know he drove to court, but he's not been charged for driving to court today. He's been charged for driving to court 6 weeks, driving somewhere 6 weeks ago. Does he deserve a lesser defence because he's creeping me out? Do the police deserve a free pass when they're disorganised?
I feel like unfortunately in that one you're a bit stuck if you've got no one to fight you on it. But I feel like in other cases where it's a bit more nuanced and it is a bit more grey, that it's not about putting up a core argument. It's actually about making a strategic decision of what argument is true or true.
Well, and we do talk about this. So you do have your primary duty is to uphold the law, and you have a duty to the court. So you need to advise the court of all relevant cases, including cases that get decided after you've put your arguments to the court. Something else happens, you need to tell the court. You have that obligation.
But you're not obliged to put positive evidence against your client to the court. If you stumble across it, you don't have to notify anyone that you found this evidence, do you?
In criminal proceedings,
criminal
no.
proceedings.
No, but you can't deny its existence if it gets called for a discovery or otherwise.
So you don't have to help the opposition.
You don't have to help no, you're not there to help the opposition, but you are there to assist the court. So if the question gets raised, you can't lie. You might be in a position where you have to withdraw from acting if you don't get instructions to release the information.
Well, I was going to say, like, that's sort of the point, isn't it, about what instructions you get from the client. So, like, in that example where, you go, based on the evidence the prosecution put forward, it looks like yourself. This is what, put it that way, but it looks like that.
In my courtroom, you can put it like that.
Yeah, you leave a really strong argument against you. So you advise your client, look, it's my professional legal opinion that you should probably plead guilty or what have you. The client says, no, I want you to get me off or try and just do something contested, make them prove it. That's like something I've heard someone say before, like, I want to make them prove it, even though they were dead to rights. And that's where you go, this is the instruction I've received from my client. So, yeah.
He's entitled to do that.
We sort of like,
I want the police to be organised. Like, at the end of the day, I want everybody to do their job.
And if you have been to court and watched, especially in criminal matters, the police are very, very disorganised. More often than not.
Surely it's kind of a societal check to prevent
maybe,
arbitrary decisions.
Yeah. Maybe not in like the more serious, obviously.
No.
But like if you go to the magistrate's court and this is the police prosecutor, they usually get torn to shreds because they usually
It's
disorganised.
it's.
But I also watched something the other day on TV, and it was like Peter Farris, who's a super successful defence criminal. And he's like he always says, I never want to know if my client's guilty.
Yeah.
He says straight away, like, if you're guilty, don't tell me. Like, because like the second...
No, well, I think he actually phrases it, and it's quite common.
Yeah, he says it all the time.
I don't want to know whether you did it or not.
Yeah.
That
Yeah.
Don't tell me.
Yeah.
Only answer the questions that I ask you.
Yes, he has a real specific
Right
approach.
from the very beginning.
The guy who's defending Borsay Ristevsky, the guy who's accused or was suspected of murdering his wife,
Yeah.
has given him, this is what the police would do if they were investigating a murder.
Yeah.
So he's kind of,
Because I think he.
that's a framework
Yeah.
for how they would do it, to the hint, stay one step ahead of them when they do this. He admitted that, he came out in the meeting, he said
Yeah.
he told his client that.
So bad.
But his client's, that's in his client's best interest at this stage.
But also with that though, like the rules of evidence prevent the police sort of coercing that kind of stuff out. So like I get exactly where you're coming from. Like it shouldn't be his role to instruct his client. I mean, obviously you can say like, don't answer. Well, these are the questions they're going to ask you.
But I guess again, we asked ourselves this question last week: what is court for? Is it a place or is it a service? And maybe now's the time when we ask ourselves also, well, what are the rules of evidence for? Are the rules there to make it easier to get the bad guy? Or are they there to ensure that we have this very high standard of proof and that we have fairness, procedural fairness in the way that we deal with people? Everybody in the process has a different role.
Yeah.
And if everybody's doing their job properly and is appropriately resourced, the theory is it should work out awesome. This is why I'm all in favour of robot judges. Thinking, no unconscious bias, they've just got what's programmed into them. It's like, we could deal with this. Because the other thing you could do, if you had robot juries, and I am being kind of provocative here, but things that were said in court that turned out to, the objection gets held. They can forget. They can forget that. If they're told not to draw an inference to something, we can program them to just forget that bit of information. They're not going to take into account all of these other things.
Directions to a robot jury might have more weight than to an actual jury.
The problem being with the jury, you're meant to have a cross-section of public, so it's like, how do you program these biases into the robots that they're meant to have? Like, how do you make them a little bit
I really like
racist?
that. So we need some social media robots, we need some darknet trading robots.
Because otherwise
I think they already exist.
you can't program jury robots in the same way you'd program a judge with all that legal knowledge. So it's kind of like how much information.
I shouldn't be the one taking you off course here, but it does amuse me, this idea. But it does. There is value in standing back and saying, well, what is this for? What is the advocate for? What is the judge for? What is the prosecutor for? What are they supposed to be doing here? Why do we have a solicitor and a barrister? What are their roles and how do they fit together? Because if we remember the big picture, then the rules themselves make a little bit more sense. And it gives us the opportunity to question them over and over again too, because times change. The next thing I want to talk about is the retainer and the contractual nature of the relationship that we have with our client. But there are a couple of other little clienty focus things that I want to throw in the middle. So, what does a retainer do? Sounds kind of really obvious, but one of the key roles of a retainer is to identify who your client is. I couldn't have prepared George's little story earlier any better, because the situation that she described, where her client was the elderly woman who didn't speak English, yet the meetings were with other people, her husband, her son. Identifying who our client is really early on, particularly if we do need to take a zealous approach to protecting our client's interest, is really important. Sounds really easy, but can be really difficult to do. The retainers also describe what the lawyer is going to do, the legal services that you are going to provide. They identify who it is that's giving instructions. Isn't that always the client?
No, if you've got someone acting on behalf of the company, for example.
Yeah, company is a really good example. So our client might be a company, but we can take instructions from the director, the in-house counsel, the mailroom clerk, whoever it says on the document we can take instructions from. Like any contract, a retainer outlines what it is that you're going to do, what services you're going to provide, and the retainer also provides the costs agreement, so the details of who gets paid for what. Up until relatively recently, in most commercial legal transactions, that payment amount was usually an hourly rate. And it's not that unusual to see it. I mean, I still think it would probably be the majority of times. An hourly rate is, at one level, the easiest way to compare apples with apples. You can go to different firms and what's your rate, what's your rate, what's your rate? That's easy. Of course, everybody takes different amounts of time to do things, so it very quickly becomes very difficult to actually ascertain what an hourly rate really means, what it actually stands for. These days we see a lot more of what we call value billing, where rather than estimate how long it's going to take and then multiply that by the hourly rate to get a number, although often I think that's probably how it's done, a quote will be given based on what the anticipated value is to the client or otherwise. So again, Georgia gave us a good example earlier when she was talking about firms of solicitors who will act based on the amount of costs that are likely to be awarded. And so she said, well, the court's never going to, for a debt over X, it's never going to award costs greater than $1,800. So rather than quote an hourly rate, a retainer agreement in that circumstance might just quote that fixed amount. Now, we spend quite a lot of time over the next 4 weeks coming back to the money issues. It's not only because lawyers are fixated by money, though many are. It is partly because you've got this far through your degree, and often we don't talk about the money and we don't talk about how the business is run. I might have said this to you last week, but I still remember the first month when I was a proper solicitor doing proper work in a law firm, and I'd worked in this same or a different firm and then that firm, in large law firms for probably 2.5 years at that stage, and at the end of the month I'm suddenly being told that I need to do my billing. And I'm just like, I didn't know I have to do, I'm really important and I'm like a lawyer now, and I just didn't know that I had to do the billing. I thought we entered those timesheets and somebody else would make those bills happen. Never dawned on me that I'd have to actually physically create the invoices and follow them up when they hadn't got paid and stuff like that. And that is part of the business of lawyering. So it's also one of the areas where lawyers have the greatest number of disputes with their clients, is over their fees or the way that they've built. It's all been billed, and it's also one of the areas where we have the highest amount of regulation as well. So it is important to understand it. Sorry.
I was going to ask, in regard to payment, when you've got a retainer, do you need to update it every time they get a different legal issue, like every year? Like, do firms put up their costs each year?
Mostly, yes. They often change their costs. The way that retainers work is they are, unless it says otherwise, your starting point is it's per engagement. So if you come to retain me to help you with your conveyancing, we have a retainer that deals with that. I might put an hourly rate in there. Chances are, because I'm a lawyer with some experience and it's not my first rodeo, it'll have a clause in there that says if you engage me to do other work, unless we agree otherwise, these same rates will apply. So I'll capture it in my terms and conditions that way. But you've got to remember, there's not a lot of equality of bargaining power here. One of the things that we'll get to, and actually I'll move on to this next slide, is the attempt that I have at summarising what the uniform law says needs to be in a retainer, but really all states in Australia, even those who haven't adopted the uniform law, have these same requirements. One of the things that I find quite amusing about it is, where is it on? Hopefully I put it on the list. Your client's right to get advice. Don't tell me I haven't put it in the list, that's really annoying. But essentially one of the things that you need to advise your client under the retainer is that they've got the right to go and get legal advice about the retainer. Because they'd need to go and get a retainer with another lawyer to do that. Chances are you'd have a conflict of interest if you were to advise them on the other firm's retainer, given that they're about to advise in relation to your retainer. So they'd probably need to get a third one. And yeah, the irony continues. Very annoying. It must be on a subsequent slide. But as you can see, there's a lot of things on this slide already, basis on which costs will be calculated. Your right to negotiate, to receive a bill, to request an itemised bill, to be notified of substantial change to the matters that are required to be disclosed. So the things that are required to disclose include hourly rates or fees, timing, fee estimates, etc. An estimate of total legal costs, or at least a range that the costs are expected to fall within, and details of the intervals at any which the client's going to be billed. If you're going to charge them interest on overdue costs, the rate of that interest that you're planning to charge. You don't do that, you can't charge it. Litigation in particular, litigation can get very expensive very quickly, and the legislature has traditionally responded to issues like this by requiring more and more disclosure. The funny thing is, the more disclosure you give people, the longer the document gets and the less likely they are to read it. But even so, we deal with this with disclosure. So often in litigation matters, retainers keep having to be updated very regularly because you just don't know what is going to happen at the next stage. So you can only estimate out to a particular milestone, and then at that point you have to seek instructions to move forward. Who to contact to discuss costs, avenues for dispute resolution. So in a firm, generally, the retainers will state the name of a partner or a person on the management team that you can talk to if you're unhappy with the bill, who's somebody who's not working on the matter, so that it can be ideally dealt with in-house before it gets referred out to the Legal Practice Board and Commissioner or otherwise. Statements that that a court order for payment of costs might not cover all costs. So we'll talk about party-party costs and party-client solicitor costs going forward as well. So all of you have done contract at some stage. All of you would feel fairly confident thinking about, well, if I really had to write a contract, I could sit down and think about what I'd put in it, I'm sure. If this is our contract with the client and these are the kinds of heads of things that are in there, what's missing? This is what the law says has to go in the contract. This is what lawyers do, isn't it? We're looking for the gaps. What's missing? If you were a client, what would you want to see in the contract? Anything? Nothing? Somebody, Simone.
Get in return.
Yeah, what they get in return, it's all about the money. It's not. Now, what will happen as a general matter is most people will write their costs agreement to say something along the lines of, yeah, we'll endeavour to return your phone calls within a couple of weeks or whatever your KPI happens to be, that we'll try and write to you in language that you can understand. If you've got questions, you should feel free to ask us, but we'll charge you for that or we won't charge you for that, depending on how it works. I mean, to me, this seems very focused on just one element of what's a really important relationship. Now, mostly I've worked in a commercial context with, my clients engage me multiple times to do similar things over and over again. But when we're talking about personal lawyering, I mean, how many of you have got a lawyer? I don't have my lawyer. I have an accountant, but I don't have a lawyer. Most people other than through their commercial lives, will deal with lawyers when they make their will, maybe, when they buy and sell a house, less likely than ever these days, but maybe. Somebody that they love or who loves them dies and leaves them money. Maybe if they have a fight with a neighbour over the size of the fence, or, you know, their 18-year-old gets picked up for hooning or something or other, they might, you know, most of us, these are one-off, once-in-a-lifetime relationships. And yet there's lots of stuff in there about the money, and we don't actually dictate the stuff about what we're going to do and what they should expect. And that's something I want you to think about, because when you're setting off into your life with clients, maybe the contract isn't the place to do it. Heaven forbid a contract lawyer doesn't think contracts are the beginning and end of everything. But we do need to think about our relationship with our clients and what their expectations of us are and what our expectations are of them. And when you think back to your own career before you came into law school, you now use language differently from the way you did before. You structure your thinking about legal matters in a different way from what you did before. Depending on the kind of lawyering you do, actually stepping back into the shoes of that person that you were before you came to law school, an intelligent, reasonable person, you deserve to have what's happening, probably feels like it's happening to you, explained to you in a reasonable way without worrying that it's $100 for every 15 minutes that you're spending with this person. Another sermon. How unlike me. So we spoke a little bit about unpopular clients already. I want to talk about this question, who the client? I've got my verb in there. Sentences are always better with a verb. Who is the client? Okay, if we're acting for a business, who's our client? If the company owns the business, or the business is owned by a company, absolutely. But businesses can be owned by all sorts of things, can't they? A business by itself is not a legal entity. A business is, in a sense, it's a verb. A business is the thing a company does, or a partnership does, or a sole trader does. It's the thing a university does. A not-for-profit could have a business. So if you are working for, or you're asked to work for a business, identifying who owns the business and who your client is your first step. Corporate, or a corporation, we spoke about that before. The company is our client, but we need to work out who we take instructions from. Directors were put forward. Now you will most likely, everybody on company law, probably come across this in other places. I think it's section 124 of the Corporations Act. Essentially says if we've got a company and it's got a name and an ABN, and the person who's representing it is a director and looks like a director, feels like a director, is otherwise a director, then you can assume that your instructions or your contract that you're making is with the company. Companies can sign in the ways that Section 127 of the Corporations Act says. That one I know the number because I have to see it all the time. So again, sole director signing by themselves can bind the company. A director or two directors, or a director and a secretary. If the company has a seal, it should use a seal, but just using the words in the manner of 127 is fine. What about in-house? We had a group before last week who were looking at working in-house in a company. Who's your client if you are an in-house counsel? Or do you have a client at all? Don't you just have a boss?
I would have thought duty to, either the director or the CEO would be your ultimate client.
That's probably who you'll take instructions from.
Well, I think you take instructions from lots of people when you're acting in-house. You get all aspects of the business
So what
coming
happened?
to you for legal advice.
Yeah, absolutely. And
but-
depending on what the policies are, you might be able to take instructions from them or not, depending on what it is.
But ultimately,
But your client, anybody else have any other take on that? Is the client the CEO or the directors? Is the client the board?
Could it be the person asking the work of you?
Well, that's your instructor. They might be your client. You might be, often working in-house, you refer to them as the client. So, and in fact, large companies will have budgets that are set up so the marketing department, for example, will essentially buy X amount of your time each year, and you will act for the marketing department, give the marketing department advice. But are they actually your client?
I would say the board would be, because they're answerable to the shareholders.
Their
or
answer.
to the company constitution, which you ultimately have to kind of be beholden to in some way.
Anything else? Your client, when you're in-house, is, well, you'll need to work it out each time, but is most likely the entity that employs you or the parent company of the entity that employs you, whichever. So it's the company. So you'll actually, the voice, the person, is likely to be, well, it could be anyone in the company as you state. It's likely to be, there'll be policies with clear lines. The ultimate client is probably the CEO. Most in-house counsel will report to management, not to the board, though it's not at all unusual to have the most senior legal officer, so often called general counsel, corporate counsel, attend part, if not all, of board meetings. This is really important because it's really easy to end up with the potential for a conflict. When your employer, the person or the entity that decides whether to pay you or not, is also your client. I was in-house for a number of years, and the last 8 weeks of my life in the job before last were probably the most difficult 8 weeks in my entire legal career. I was actually I was on the board of the company as well as being general counsel. The non-executive directors came and spoke to me. The company was performing badly. We launched a fund in, this is 2008, we'd launched a fund in the UK about 3 weeks before Lehman Brothers collapsed. So it's possibly no worse time to have new products in financial services. We have very big personality CEO who just believed through force of might it would get better, and it wasn't getting better, and the non-executive board members had engaged somebody to come in and do a review of a range of different things with a view to seeking some additional funding. Long story short, the person who conducted that review, the non-executive board members decided that they were going to sack the CEO, who was a founder of the company, and put this person in place. So my boss is about to be sacked. I'm on a board that's supposed to make that decision, but the non-executive directors have effectively tried to make that decision by themselves. They were a majority, so if they all agreed, they could definitely make that decision. There's a clear potential conflict of interest that somebody who's come in to give us advice, his advice is that we should sack everybody and give him a job for a very large clip. There were a range of different issues that were happening, not the least of which is that I knew once the CEO went, it was possibly days, if not weeks, before I was turfed out the door as well. because we're political animals, right? We understand the politics of the situation. So what can I do? What can I do? Now my boss, who I'm supposed to get instructions from, is the CEO. The board tell me this is what's going to happen, this is what we want to do. You're not allowed to talk to your boss about it.
I think you're bound to the.
So what do?
You're a board member.
That's an added complication, I admit, but I think that the logic still falls the same way anyway. There was an added complication that I was a board member. So then the question is who do I have a duty to as board member? My client. Well, no, as a board member, I have a duty to the company.
Yes.
But what does that really mean? My boss is also the majority shareholder.
Just break out every little
Or the
part.
largest shareholder, not a majority shareholder. So he held about 20% of the company at that stage, so not enough to necessarily stop what was happening. But he was still, so if our duty to the company is a duty to the shareholders, but as a director, I can't just go and talk directly to the shareholders. But can I do that as a general counsel? Talk to the shareholders? My duties to the company? I'm very glad you're absolutely right. I cannot go directly to the shareholders because I've got a duty to the company. And the duty to the company is something much more amorphous than just to the shareholders. It encompasses employees, it encompasses creditors, it encompasses as if the company was a separate thing, even though we know that it's not.
So if you have two fiduciary duties running parallel, one for the client, one for the company.
Yeah, they were both the same thing in theory, but
Yeah.
in practice possibly different things.
Which one usurps the other?
Well, in the end, I resigned as a director initially. It was very clear that I would be asked to leave that once the old guard left anyway. I still must admit on the director side, I'm not sure that that was the right thing to do, but I couldn't actually match both. I couldn't do my job as a director and do my job as counsel, and I was paid to be counsel, and I was an executive board member, so it made sense for me to, at the time, actually I didn't formally resign it until afterwards, but I withdrew from attending the board meetings on that matter, those matters. But yeah, it's a tangle of web that you end, and there's a lot quite sensible people who would say that there should be a separation between general counsel and the board for those reasons. Because and non-executive directors, generally in ASX listed companies anyway, you can see it in the disclosures, will have usually a right to go and seek separate representation, and it's quite unusual for a general counsel to advise non-executive board members or board members generally on their personal legal issues associated with their performance as members of the company. But you're always asked, every in-house role I've ever had, I'm always being asked by directors because they know that you understand all of the issues. They know you understand the complexity and the nuance of it. But it can be quite a difficult thing to do.
And the CEO lost his job.
Yeah, CEO lost his job. I lost my job. We got big payouts though. Should have gone and been a ski instructor then.
So what happens for lawyers who sit on boards, which happens quite often, but they don't actually work in the same capacity that you did? If you're getting
When they're non-executive directors.
Yeah, so they're non-executive directors, they might have a law degree, but they're not working as a lawyer. But say these board members actually, they're asking...
Well, I think if they're not working as a lawyer, so if they don't have a practicing certificate, then uniform law and its equivalence in each of the jurisdictions says they can't give legal advice, right? You give legal advice without a practicing certificate, you're breaking the law. Okay. But, so there's two categories of lawyers who sit on boards. One is, like you say, people who've got legal training, but they're not necessarily practicing as lawyers anymore. Presumably, the way we think, attention to detail, that ability to divorce emotion from the logic, part and parcel of the reason that they've been chosen to do that job, and they bring those skills. I don't see it as being any issue. unless they start to give legal advice or go into that area where they might be breaking the law personally, but it's probably not really exposing the company to a great deal. And smart people don't do that. They don't give legal advice, but they're really good at working out where they might need legal advice and isolating the clear questions to be asked. The second category is lawyers who are practicing lawyers who take on non-executive director roles. And again, they probably fall into two categories too, at risk of oversimplifying. Not-for-profit, pro bono type roles, where there's a cause dear to their hearts, where they might be involved as a trustee, which is a similar role to being a director for an estate, a client's estate or otherwise. Actually, no, I'll put that in the commercial basket. But if there's stuff that they're doing, they're bringing their legal skills. The not-for-profit is usually looking for their wise counsel, but also hopefully a bit of free legal advice on the side, because that's bloody expensive and we're a not-for-profit. They will often have an issue too. Anyway, when we think about that separation, having obligations, fiduciary duties as a director, and then fiduciary duties as a lawyer. Now, often how that will play out in the larger firms, they will be able to actually separate out, they'll be able to work under their pro bono plan and say, okay, this firm, we will give legal services, but we're going to separate out. And the person who's on the board won't actually act in the matters, but will be, instructing in them in some way. Still has some issues, but usually we get around it. Back in the 70s, 80s, even into the 90s, there was a bit of a trade in partners in law firms becoming directors of clients. Basically, it's part of the way of securing the relationships and getting people, making sure that you were regularly instructed, knowing very early on what the issues were. It was as much marketing as anything else. I might be being a bit cynical saying this, but I worked in commercial firms. Most of the partners that I worked for in the late 80s, right through really into the middle of the 90s, it was not at all uncommon for them to sit on the boards. I think whilst we all knew back then that board membership was not just a cosy way of being sort of paid out into your retirement, and that directors had duties, the seriousness and the importance of them has really played out in the last 15 years in a way that wasn't contemplated earlier on. And it was really, nobody would have ever said it out loud, this is marketing, but it was marketing. Looks like a duck, smells like a duck, quacks like a duck. You go and sit in a boardroom once a month and come back with a whole series of instructions on new matters, that's marketing. And that's used to be what happened. Now it's it's much more nerve-wracking than it's ever been before to balance those duties. Again, if I had my time over, I think I would have chosen between general counsel role and the executive director role that I had. I don't think it was the wisest thing to run them both at the same time. I didn't get myself into any trouble. There was no, but it was, those last 8 weeks were very difficult because whatever I did, I breached my obligations somewhere. Unless I did nothing. And given that I was being paid substantial amounts of money, doing nothing didn't really feel like a great option, if nothing else. What about acting for an insurer? Well, when you get instructions from an insurer, think about all those tort cases that you've looked at over time. Think about how most likely those trip and slips that seem such small amounts, why on earth did those two brothers go to court? And the likelihood that there was an insurer sitting behind that. Who are you acting for when you act for an insurer?
The underwriter of the insurance, I would imagine, really ultimately. I mean, I guess that's indirectly you're
That's who you're getting your instructions from. That's probably who's paying you even.
Yeah.
I think you need to be clear. You need to be clear on your retainer. Are you acting for the insurer or are you acting for the insured? Because they don't always have an identity of interest. So if you are acting for the insured, then that means that you need to be able to act zealously against the insurer. But if you are acting for the insurer, you might be acting for the client in name only, because the insurer has a right of subrogation, so a right to take over the action and fight it out. They pay out, or otherwise their client, their customer, but then they fight out the issue in some other way. You need to be very clear who you're acting for. What about children?
Depends how old the child is. Is it about 12 from criminal law, or they can be
They can-
self-sufficient in terms of giving you instructions?
Basically, the judge will make a call. One of the observations people have when they're sitting up in the children's court looking at issues, and there are many observations that come out of that particular jurisdiction, is how often, particularly in matters relating to custody, that you have a courthouse full of lawyers. Each child will be separately represented, parents will be separately represented. Again, you might feel like you're acting for the parent, but if you are instructed to act in the best interest of the child, then if you're being instructed in relation to or representing the child, then you need to act in the best interest of the child, which sometimes requires getting separate social work or other assistance for the child, even if the child and their parents don't feel that they need it. Again, that's the reverse of the situation Georgia was talking about. The elderly woman who doesn't speak English probably feels much more comfortable with her son doing the translation for her than a complete stranger. But to act in her best interest, it makes absolute sense for Georgia to speak to her through a properly qualified translator, separate from the son and the father, to make sure that she's in a position to take appropriate action if she needs to. And that, we use this terrible phrase, adult with a disability. A disability can include just not speaking English, which is unfair language to say the least, but I think we understand the broader context of that. We're getting on. I'm just going to have a look and see if there's anything in particular. I'm just going to go with this last slide. So I just want to finish off with this idea of how strictly the duties are applied. So what happens if a lawyer is acting bona fides, in good faith, but ultimately ends up with an advantage as a consequence of some dealing with his client or her client? What happens if ultimately the client benefits from the breach? Money used instead of inadvertently instead of put in the trust account, got put on a long-term deposit, and it was in a hedge fund, but it worked out okay, and they actually benefited. They've got more money now than they did before. Is that a breach of a fiduciary duty? Or if it is, let's say it is, because it is, will there be a problem? Well, what's happening here? What happens when there's a breach of duty, but it happens because just something went wrong in the office procedure? It was delegated to staff, Because the staff, you know, they're not lawyers, they can't possibly understand that if that deed is not properly looked after, there's a risk that it might be stolen and there could be an issue with the property, underlying property.
Agents, duties done that, but you do have the same fiduciary duty.
Yeah. So I've got a case in relation to each of these here, sitting underneath. I'd forgotten that's what that's waiting for. What's going on? Come on. No fees were charged. At the end of the day, there was a breach of a fiduciary duty, but I didn't make any money out of it. I didn't charge. It was all pro bono. Am I going to have a problem? Yes, you are. And then there's the good old commercial reality. Just seems to be a better result commercially if we just deal with this. I can't actually, if I look at every potential conflict of interest, then I wouldn't be able to act for anybody else in Melbourne, you know. I act for Telstra. Everybody in Melbourne's got some sort of commercial relationship with Telstra. That would be just ridiculous. Surely not. The reality is all of the fiduciary duties are absolutely strictly applied. But it is that commercial reality, bizarrely, the one that sounds the most ridiculous, is actually the most difficult in practice. And I think when you look at information barriers, or the old term for that was Chinese walls, you will see just how difficult that is. But as law firms get bigger and bigger and become significantly large businesses, and clients get smarter and smarter, so one of the other tactics that British American Tobacco was quite well known for is instructing all of the large law firms on small matters. So it was very difficult for people to bring actions against them because there were conflicts of interest in all of these places. Clients get smart too. All right, we're at about 20 past, and I do understand that you guys have got places to go, and we sort of finished a bit early. Thank you for having me today. I hope you got something out of what we're doing. Really, all of today was trying to do was to give you an introduction to the kind of issues that you're going to need to deal with. The reading lists are there for you to get your heads around, and next week Adam will go into the fiduciary duties in much more detail. So thanks. Questions, comments, surprises, get onto the discussion board. Do not forget that you have an assignment due, your first post tomorrow night at midnight. And also, sorry, I forgot to remind you, there is a national survey that the Australian government is doing called the Student Experience Survey. You will have had an email about it. It takes about 10 minutes. I cannot overemphasise how important getting participation in those surveys are. I know they're boring and dull, but they matter. So have your voice. If you're not going to vote in the plebiscite, get on the Student Experience Survey.
Thank you.
And there, I finish with a nod.